Good afternoon, everyone. Thank you for joining us today. My name is Louise Azzarino and I'm one of the Deputy Ombudsman at the New South Wales Ombudsman's Office. Today we've got an interesting panel discussion about the new PID Act 2022, and we have the privilege of spending an hour with these esteemed panellists. Just before we get started, I want to acknowledge that I'm hosting this session from the country of the Gadigal people. I also recognise the traditional owners of the countries where you all work today and the First Nations people who are joining us today. I pay my respect to all elders past and present and celebrate the diversity of Aboriginal and Torres Strait Islander people and their cultures and connections to the land and waters of New South Wales. Just before we get started, we do have a Q&A function today at the top of your screen. As we move through the session, please send through any questions that you have. In some cases, staff from my office will answer any of the questions quickly in the chat. We will also put some of the questions to the panel for discussion. If there are any questions that we don't get to today, we will answer those at the end of the week and distribute them amongst those of you who have attended. So it's time now to introduce our panel. So we have Matt Richards from the Cabinet Office. Matt is currently the Acting Deputy Secretary of General Counsel of the Cabinet Office with his job share partner Mark Hare. Mark and Matt have job shared the role of Executive Director, Legal Branch of the Cabinet Office, and before that the Department of Premier and Cabinet since 2020. We also have the Chief Commissioner, John Hatzisagos, AM. Mr Hatzisagos was appointed Chief Commissioner for a 5-year term from 7 August 2022. He was appointed as a judge of the District Court of New South Wales in 2014 and was an adjunct professor of law at the University of Technology, Sydney from 2011 to 2021. Between 2003 and 2011, Mr Hatzisagos was a Minister in the New South Wales Government, holding portfolios including Attorney General, Minister for Justice, Minister for Regulatory Reform, Minister for Health, Minister for Industrial Relations and Minister for Fair Trading. He was Chair of the Joint Committee on the Independent Commission Against Corruption from 1999 to 2003. We also have with us the New South Wales Ombudsman, Paul Miller, PSM. Paul was appointed to the role of New South Wales Ombudsman in May 2021 for a term of 7 years. He joined the New South Wales Ombudsman's Office in April 2019 as Deputy Ombudsman and Community and Disability Services Commissioner and was Acting Ombudsman from August 2020. Welcome to all three of you. So I might just turn to Matt and give you an opportunity to give us some of your remarks about the PID Act.
Thank you very much, and lucky to be able to go first. So I thought I'd start by talking about the importance of the PID Act protection. So the PID Act is such an important act because it has at its heart a really important and noble principle, which is that public servants should feel comfortable speaking up if they see wrongdoing, because they know that they'll be protected, that they know that if they do speak up, they won't suffer negative consequences. And for that reason, it's such an important act, and so good that we're doing this session and this week to make sure that people are aware of the protections and how the Act works. The second thing I thought I'd talk about quickly was the involvement of the Cabinet Office in relation to the PID Act. So the PID Act is jointly allocated to the Premier and to the Special Minister of State, and the Cabinet Office supports the Premier and Special Minister of State in relation to the administration of the Act and amendments to the Act. TCO is also a member of the PID Steering Committee, which is set up under the PID Act, which is chaired by the Ombudsman and also includes the ICAC and other key integrity and oversight agencies. I thought I'd also quickly talk about the development of the new PID Act. So the former whistleblower protection legislation in New South Wales was the 1994 PID Act. The current Act is a significant improvement on the old Act, both in terms of clarity and also in terms of increasing protections. So in October 2017, the Parliamentary Committee that covers the Ombudsman tabled a report into the 1994 Act, making 38 recommendations for significant reform to the old Act. The PID Steering Committee also has a statutory function of advising the government in relation to the Act and any recommended changes to the Act. So TCO worked very closely with the PID Steering Committee over a significant period of time with a number of meetings working through the key concepts and principles of the new Act, taking into account the recommendations of the Parliamentary Committee as well as the recommendations of the PID, the Statutory PID Steering Committee. So there really were a lot of inputs to the new Act. There were the inputs of the Parliamentary Committee process, including all the witnesses and evidence to that process. There was significant inputs from the PID Steering Committee, chaired by the Ombudsman, and then there were the usual Cabinet and parliamentary processes for passage of the bill.
Thanks, Matt. It's certainly interesting to understand the lead up to the new PID Act. Chief Commissioner, did you have some remarks for us?
Well, first of all, I'd like to thank Paul Miller and the Ombudsman's Office for giving us this opportunity to participate in this important information session. Can I just say that for agencies like the New South Wales Independent Commission Against Corruption, we're dependent, obviously, on matters being referred to us by agencies and by individuals, and the vehicles by which that could be done include protected disclosures. Without information coming to us from a variety of different channels, we'd be unable to function. That doesn't necessarily mean that we'll investigate everything, but in many instances the information that we get provides us with a useful database of information which we can act on at appropriate times whenever the need arises. So when we look at our investigative work, if you look at some of the investigations that we have undertaken, they've arisen out of anonymous calls or complaints that have been made over the telephone, or in some instances under Section 11 of our Act, where agency heads are obliged to make those referrals. And in each of those instances, persons who've made those referrals to us have felt the need to be able to do so external to their own organisation. Sometimes they've received complaints internally, and where reasonable grounds for suspicion of corrupt conduct has arisen, compulsory referrals have been made to us. So if you look at, for example, some of the investigations that we've undertaken in Operation Hector, which was an investigation which started off with Inner West Council, that was as a result of a referral which came from an anonymous complaint. As a result of that anonymous complaint, we were able to look at that matter further, and we found major corruption affecting not just the council but also Transport for New South Wales. So it's evidence of how a relatively small matter can germinate into something quite substantial. It is important also to contrast the situation where we get those sorts of referrals coming through to us with a situation which arose in Operation Keppel, where there wasn't a complaint, there wasn't a referral. We came into that matter by investigating an entirely separate matter involving the Canterbury Council, and as a result of that investigation we detected information on telecommunications intercept which made us suspect that there was corrupt conduct, and then we opened up the Keppel investigation. And throughout the very long and complex Keppel investigation, which has been now uncovered in our report, where we saw quite significant, serious and systemic corrupt conduct, there was not a single instance of referral to our agency, in circumstances where we also found that there was an obligation on a senior decision maker, namely the Premier, to refer that matter, and we found in that instance corrupt conduct as a consequence of a failure to refer. We do recognise that there are circumstances where it may be difficult for people to make that referral. We're anxious to provide whatever protection can be, and the PID Act does provide us with a vehicle to be able to provide protection in a wider range of circumstances than was previously the case, so we do acknowledge that. There are a number of different means by which people can make their referrals to us, but the PID Act is an important protection, an important vehicle by which that information can come to us.
Thank you. It's important to have those practical insights into the application of the PID Act. And Paul, as New South Wales Ombudsman, what's your view?
Yeah, well, I think Matt's introduced the new Act well, and it is important to recognise that that new piece of legislation, which commenced in October last year, is a significant improvement on what was the 1994 originally Protected Disclosures Act. What I want to focus on very briefly is the role of the Ombudsman under the new legislation and the way that the Ombudsman and my office are trying to support both agencies and public officials in this space. So a couple of functions that we have specifically under the Act include to promote awareness and understanding of the Act generally, which we do by events such as these. Other things that we've done is made available awareness videos and distributed those to the sector. Related to that broad awareness and understanding role is an ongoing role of providing information, assistance, advice and guidance. Again, both to agencies that might receive PIDs, but also to public officials who might find themselves in a position where they need to make a PID. In relation to agencies, there is on our website a now extensive comprehensive range of guidelines on the operation and meaning of the PID Act. For those of you who have the opportunity to read the Act, you will see that it is written in plain English, so it is a piece of legislation that you can read from beginning to end, and generally speaking, it will be understandable to you. But the guidelines, nevertheless, are very helpful in terms of teasing out some of those nuances around what can be reported, what are the particular protections that apply to you. Within my office, we have two PID advice teams. We have a PID advice team that is focused on providing information and assistance to agencies. So this is agencies who come to us often on an ad hoc basis looking for guidance on how to navigate the new legislation. It's probably important that I caveat our role in this respect by noting that we aren't authorised and able to provide legal advice or specific direction on how to deal with a particular PID that might come to an agency, but we can provide general guidance on how the Act works and what the obligations and responsibilities of agencies are. In terms of public officials, we've only just recently established what is new for New South Wales, and I think a first in Australia among Ombudsman officers, a whistleblower support unit. So this is a small team dedicated to being available to provide advice, support and referral to support for public officials who may have made a PID or who may be contemplating making a PID or wondering whether they should make a PID or not. This team doesn't receive PIDs itself, but is just there on hand to provide guidance to public officials in what can sometimes be quite an isolating or lonely sort of decision-making process for them. We also provide more structured training to agencies, and we really have focused to date on agencies because we've been focused on the implementation of the new PID regime. So the training has very much been about helping agencies get their systems in place and ready for the new regime. A third function that we have under the Act, which will become increasingly important now that the Act has been embedded, is our auditing and monitoring function. So this is a bit of an enforcement compliance function, I suppose. There are two aspects of this. One is an annual reporting process where all agencies covered by the PID Act are required to report to us on the PIDs that they've received during the year and how they've dealt with those, and we in turn report then to Parliament about the sector experience of the legislation. And the second is a power under the Act to dive more deeply into agency systems for dealing with PIDs. At the moment, we've started a relatively light touch audit regime. We're conducting a self-assessment audit with agencies at the moment, looking at their implementation of the mandatory requirements of the PID legislation around having policies in place, providing training for their managers and disclosure officers, etc. Fourth function of the Ombudsman, and Matt touched on it earlier, is our role in providing advice to government on proposed reforms or amendments to the PID legislation or its administration, including through the PID Steering Committee, which we convene. We expect that we will identify opportunities for improvements to the PID Act, the regulations, through our monitoring and auditing work, as well as through our engagement with agencies through the community of practice, as well as by agencies proactively themselves coming to us and letting us know if there are anomalies or issues with the legislation or the way it works in practice. And the final role I should mention as Ombudsman is the role that we have similar to other integrity agencies like the ICAC, which is that being an integrity agency, we can receive public interest disclosures from any public official across the sector, and the no wrong door approach of the PID Act means that although as Ombudsman our focus is very much ourselves on serious maladministration, and that's the area that we are most likely to take action and investigate, a PID about any of the categories of serious wrongdoing under the PID Act can be made to us, and if it's a matter that we won't ourselves investigate, then we can make sure that it's referred to the appropriate agency, whether that's the ICAC or the agency itself, to deal with and investigate.
Excellent. Thank you for that holistic overview of how we oversight the PID Act. Matt, could you tell us a little more about some of the key aspects of the PID Act? We've already spoken about protections, perhaps the no wrong door approach.
Yeah, so I thought this was a good opportunity to talk about the no wrong door approach. So this was one of the key reforms in the Act. So under the old Act, different types of PIDs needed to be made to different recipients, and if you made your disclosure to the wrong recipient, you weren't necessarily protected, and it was a complicated matter. Under the new Act significantly simplifies who you can make disclosures to, and it makes it much easier for a person who's considering making a disclosure. So voluntary PIDs can now be made to the head of an agency, including the head of any integrity agency, as Paul's just noted, a disclosure officer that's designated for an agency, but also, really importantly, the person's manager. And so that's one of the key reforms in the new PID Act to make it easier for people who want to make disclosures, is that you can now make a PID to your manager, who's someone that you know and you work closely with, and you don't need to work out, oh, it's this kind of PID, I needed to make it to this person. You can make it to your manager as well as those other recipients. So to go with that, there has been compulsory training for all managers so that managers know what to do with PIDs when someone makes a PID to them, and making sure that managers get those PIDs to disclosure officers for agencies so that they can be dealt with by the agency and potentially referred to another agency. Yeah.
Thank you. Did either of you want to add anything about some of the key aspects of the new Act?
No, but I did just want to pick up on that, the no wrong door, and particularly the ability now to disclose to managers, because through our work in raising understanding and awareness of the Act, this probably is the key message that we've been out there trying to get across to agencies, is quite a fundamental shift in the legislation, in the sense that under the 1994 Act, the responsibility for getting it right, making the disclosure to the right person about the right thing, was very much on the PID maker, and if they got it wrong, they were not protected at all. The new Act really shifts that burden now to the agency. So no wrong door means that any PID from any public official can be made effectively to any agency. But it also shifts responsibility down throughout an agency, because it means that any manager, and that means anyone who manages staff, you don't have to have manager in your title or executive in your title, may find themselves receiving a PID. And so it's essential that at the very least they understand enough about the PID regime to be able to identify a PID, because it is not mandatory for someone making a PID to use those words.
Right.
Someone doesn't need to come to you and say, I want to make a PID, or I'm about to make a PID. So managers really need to be alive in all of their conversations to the possibility that what someone is telling them may well be a PID, and then that triggers their responsibility to escalate that.
Two aspects. Firstly, a PID can also be raised in relation to an anonymous complaint. That's important because a person may be concerned by making their complaint that there may be information which might otherwise reveal their identity, so there can still be an obligation to provide protection to that person. The second thing is that a PID can also be made notwithstanding the fact that there may be a duty of confidentiality or even a non-disparagement clause in a contract. So the circumstances in which a PID can be made is very much broadened compared to the regime which existed previous to the new Act coming into force, and I think that's an important and useful step forward.
Absolutely. Paul, one of the features of the Act is the call out of the obligation to have a positive speak-up culture. Could you talk to us a little bit about how you think that leaders in the public sector could support the building up of a positive speak-up culture?
Yeah, sure. I do think, along with No Wrong Door, I think this is probably one of the most significant changes in the PID Act, is to recognise the centrality of culture. And a core stated object of the Act is to promote a culture in which PIDs are encouraged. Now, there are many definitions of culture, but if we think of culture as kind of the sum total of the ways that a group of humans do things, and think about that as having some element of durability, so it's a culture that transmits from generation to generation, or in an organisation, the existing staff then transmit it to new staff who become inculcated in that culture. What we see is that it's culture that really sets the bounds of behaviours within an organisation. But most importantly, culture is about what people do, not what the law or their policies say that they do. So that being the case, even though it is very important that the PID Act does call out culture as centrally important here, it's not in and of itself going to deliver the desired culture that we're looking for, and that is what requires leadership. That said, the PID Act does help leaders in some respects by pointing to specific practices that they need to engage in that will help them to build and maintain a positive speak-up culture. And that includes the requirement that they adopt a PID policy and that they promote awareness of that policy among staff, that they take active steps to ensure awareness among all public servants of the PID Act and the protections that are available under it, the obligation to ensure that all of their managers and disclosure officers are trained. It's also important, I think, that some functions under the PID Act are expressly unable to be delegated by the head of an agency. So there is a responsibility under the PID Act on the head of an agency to ensure that there is a risk management system in place, to ensure that when people make a PID, that a risk assessment and risk mitigation steps are put in place to protect that person from the risk of detrimental action, and that is a non-delegable function. So I think those things are all very important in helping leaders try to set the desired speak-up culture. I think one of the real challenges in this space is that a PID that is well handled is usually a PID that will not be drawn to the attention of the organisation and its staff as a whole. A PID that's well handled will be one where, generally speaking, the PID maker's identity is kept confidential. If any investigation, misconduct proceedings ensued, they will be dealt with appropriately in accordance with procedural fairness, but usually not in a way that that's broadcast to the organisation as a whole. And what that means, I think, is that there's a challenge for leaders there in that it's very difficult to laud or recognise call out good behaviour. You're not going to hold a town hall meeting of staff and say, I'd like to welcome Jane up onto the stage. She's just made a PID, and we'll pat her on the back. So I think what that suggests, or what that really highlights, I think, is that when we talk about a pro-PID culture or a speak-up culture, what we need to be thinking about is an ethical culture more generally, and thinking about how does an organisation and how do its leaders, generally speaking, deal with mistakes, bad news, the advice that they didn't want to receive, because it's the messages that leaders convey when that happens that their staff are going to extrapolate then to think about, well, how will a PID be received in my organisation? And I've brought a quote on this from Paul Brereton, the NAC Chief Commissioner, which I think he's speaking about APS cultural reform, and what he says is, leaders must foster in our institutions from the top down and at every level a culture in which decisions are made and advice is given honestly, impartially and in the public interest, in which matters are reported honestly without embellishment or exception, in which staff feel free to speak up when appropriate, where constructive criticism is welcomed, where honest, if unwelcome advice and reports are not dissuaded but encouraged, in which responsibility is accepted, including for the inevitable mistakes, and in which the careers of officials who adhere to these values and do not always follow the line of least resistance are seen to prosper. So I think focusing on that broader culture is where I think leaders can have the biggest impact here.
Absolutely. Chief Commissioner, did you have some insights into building a speak-up culture?
Well, I think building a culture is very important, and what we see in agencies that have a good culture is that they are the ones that tend to report more frequently. I often say, in the context of an organisation such as ours, that we don't worry as much about those agencies where we get a high level of reporting as opposed to those where we don't see any or we see very little reporting. If I see an agency hasn't reported to us within, say, 5 or 6 years, we start to ask questions as to why. So it is very important that that culture be fostered in an organisation. We have vehicles within our own organisation to be able to provide support to people who do come forward. We have witness assistance policies, for example. We also have a witness cooperation policy, which in certain circumstances can provide some safeguards to people who decide to come forward, even if the circumstances in which they come forward may indicate some culpability on their part. So we try to foster and encourage that. Moreover, we are very keen on the concept of leading from the top. We see it as a very important cultural aspect of ensuring that agencies are led by people who embrace the importance of reporting and the culture of people speaking out where appropriate. And I should also indicate that in agencies where that does happen, we see a situation where corruption, serious or systemic corruption, is less likely to take root and germinate. So the damage to the organisation is less sustained and less frequent by reason of that culture that's been referred to.
Definitely. And obviously, accusing another public official and coming forward and reporting corrupt conduct can be a very daunting step. Do you have any advice for someone who might be in that situation?
Look, there's a variety of ways people can make reports, and I'm pleased to say that we've seen a number of instances where people have been very courageous in making those reports. We saw in our investigation Skyline, which involved an Aboriginal Land Council, the CEO of that organisation, at great personal risk to himself, gave the correct advice to the agency about what the obligations were that needed to be followed. We also saw it in Operation Whitney, where despite enormous pressure on some councillors on Canada Bay Council, there was an adherence to proper processes and proper decision making at great personal cost to them, as there was a great personal cost to the CEO involved in Operation Skyline. Complaints, of course, can come to us anonymously, and that's one vehicle in which we can receive them and we can act on them. As I indicated, we can provide appropriate protection to the identity and detrimental conduct through our own processes and also through the vehicles of the PID Act. We don't expect the matters that come to us, the persons who make their complaints will solve the cases for us. Obviously, we have an important role that our own organisation plays. But even if we don't investigate, the information that we receive is critical to us being able to build up our intelligence base of what's going on and being able to address issues, sometimes through a thematic and systemic way. For example, through information that comes to our attention, we might be able to identify that there is an aspect of how an organisation operates which makes it more susceptible to corrupt conduct, and we may be able to provide advice to the agency about how to be able to address that in a proactive way. Obviously, with any organisation, there's going to be different issues, different structures, different personalities. If someone is not confident of being able to report something internally within their own organisation, there is the vehicle of being able to come to organisations such as us, which can handle the matter apart from the agency and address it in a way which provides another layer of protection potentially to the complainant. So there's a variety of means by which a person can come forward, and hopefully that can provide some extra layer of assurance to those persons who find themselves particularly vulnerable. And as I said, with an organisation such as us, we have internal processes of being able to provide protection to a person through our witness assistance cooperation and our witness assistance welfare policy.
Thank you. We have some questions from the audience. Now, we receive in the PID advice team quite a few inquiries about assessing or the features of a voluntary PID. And I have a question here. Does an agency have a discretion to assess whether a matter is a voluntary PID? And I wondered, Mark or Paul, if you might...
I mean, the simple answer is no. So there is an obligation to assess whether a PID is a PID, and in assessing whether it meets the features of a PID, those features are all objective features. So even where the Act, for example, refers to seriousness, so some of the categories of serious wrongdoing about which a PID can be made have the qualifier serious, so maladministration is example. You can make a PID about serious maladministration. That is an objective question as to whether it is serious, and the Act actually defines serious as not trivial. So it's not a very high threshold at all, but it's certainly not a subjective threshold in the sense that the agency doesn't have the option to say, well, you might think it's serious, but it's not that serious to us. And that's true of all of those features of the PID Act. They are all objective.
Yes, and on that point, Paul, serious wrongdoing is defined to include a number of types of wrongdoing, including corrupt conduct, but the definition of corrupt conduct rather than adding another serious on top of that. Serious wrongdoing is just the term that covers all the forms of wrongdoing that are protected.
That's right. Now, we spoke before about the role of managers under the new PID Act, and we spoke about reporting being a daunting experience. Now, I have a question here about who can a public official make a report to if it actually relates to or involves their manager?
So if it involves your manager, you won't be making the report to the manager. So there are designated disclosure officers in each agency that you can make disclosures to, which is set out on your agency's internal website and your agency's policy. But you can also always make a disclosure to an integrity agency as well.
I agree with that, honestly.
And when in that situation, if you're contemplating making a PID because you have information that suggests that your own manager may have engaged in serious wrongdoing, one of the things when making a PID that is important to do is to bring to the attention of whether it's the disclosure officer within your own agency, or if you come to an integrity agency like ours, if you have any genuine concerns about the potential for reprisal, or if confidentiality, which is generally speaking required under the Act, but if confidentiality is particularly important in the case of your PID, then it's important to bring that to the attention of whoever you're disclosing your PID to. They should ask you, but it's particularly important in that circumstance.
We obviously depend on a lot of matters that come to our attention anonymously. It's a big part of the information sources that we have, and that's a vehicle that's open to people. Sometimes it's difficult for us to be able to follow up the matter because we don't know the person, but in circumstances where the level of information provided is such that it may be possible to identify the source from which it came, the PID Act obviously still applies in relation to that person, and if we need to refer that matter on, we're very, very careful about the agency we refer it on to and the level of information we provide to protect the person.
Definitely. And in fact, we have another question around the protections against detrimental action under the PID Act, and in particular, I guess some strategies about how agencies might be able to manage that risk of detrimental action from occurring.
I think the first point to make is that it's a good question to ask, and it's a question that always needs to be asked, and it needs to be asked at the very outset of having received a PID in every case, which is what are the risks in this particular situation, and what steps can be taken to mitigate those risks. It will be very case dependent. Maintaining confidentiality may be more or less important as a mitigation. Often you find if the disclosure is one where it is a matter that feasibly could have been brought to the attention of the agency by a number of avenues and not by necessarily a PID, or certainly not by a PID by a specific person, then confidentiality, and even confidentiality around the fact that this came to our attention by way of a PID may be one of the most important mitigating steps in terms of protecting people.
Definitely. Now, I have another question. This is around if agencies receive a disclosure that does not relate to that agency. What are their options for dealing with it, and what information should the reporter be provided?
So with the no wrong door reforms, there are also really useful transfer provisions for PIDs to be referred to other agencies, and including integrity agencies. So there are a number of options for the disclosure officer of the agency in relation to it, including referring it to another agency or to an integrity agency to investigate it.
Well, we supplement that, and we've got a number of memorandums of understanding with other agencies as to transfer of information, disseminations under our Act as well, which complements and supplements the provisions of the PID Act. We're obviously very careful about the information which we transmit, and certainly when the identity of the PID maker is known to us, we would consult that person prior to making a determination as to whom to transmit the information and the amount of information that we would transmit to ensure that that person is comfortable with the proposed course that we're taking.
Now, I understand that, for example, with the work of the ICAC, you talked about the benefit of people making disclosures and also the impact of people not making disclosures when they ought to have. Could you talk to us a little bit more about agencies recognising the benefit of people coming forward within their organisation?
Sure. So when people do come forward, it makes our job a lot easier, particularly if they come forward at an early stage. So the earlier we can look at the particular issues, the behaviour that's going on, the more likely that we'll be able to stop it and prevent damage to the public interest. Very often people who engage in corrupt conduct do so in a calculated way. Corrupt conduct is consensual generally, and it's got a number of willing participants. That's what makes it difficult to detect, and that's why an agency such as ours exists. When someone is prepared to come forward and give us information, then we're able to examine that information and investigate the matter and produce an outcome which is in the public interest. In contrast, in situations where, and look, sometimes that may not become apparent at first instance. It may take some time before it develops, but we'll be able to uncover it. In circumstances such as the one I described earlier in Keppel, which was a long-standing investigation, a very complex investigation, where there had been a complete failure to refer matters to us in circumstances where there were a red flag at a number of different levels. I'm not just talking at the most senior level, but I'm talking about a number of different levels, and that complicated the investigation. It made it much more protracted, and it involved us having to use every investigative tool that we had available to us in order to be able to uncover the wrongdoing in that case. And that, in those circumstances, is a greater prospect of damage to the public interest.
Now, the role of disclosure officers, quite often we receive requests for advice around whether disclosure officers are obliged to conduct an investigation, for example, and it really does depend sometimes on the size of the agency and the arrangements they have. Paul, perhaps you could talk to us about the role of the disclosure officers as you see it.
Well, as you say, it does depend on the size and nature of the agency. The most important role in the organisation from a PID perspective, beyond the head of the agency, particularly given their role in setting the culture, which is central, is the senior disclosure officer. And it may well be that for most disclosure officers within an agency, their core role is, like managers, to ensure that the relevant PID is escalated to the right level, which will be often the chief or senior disclosure officer. That said, different agencies may have different arrangements in terms of the relative responsibility of particular disclosure officers. The second key role of a disclosure officer, particularly if they are the direct recipient of a PID, so it hasn't come to them via a manager, is to provide support to the person who has made the PID. So the PID maker has chosen them, usually from any number of people to whom they could have made the PID, as someone that they feel comfortable making the disclosure to. So there's a particular responsibility that comes with that in terms of providing support to the whistleblower in that particular case. And related to that is the role that disclosure officers often have in relation to that risk assessment process. Assessing whether the person has a genuine risk or fear of potential detrimental action and what steps might be taken to mitigate that.
And alongside that, I guess, is the concept of choosing the right people within your agency or to be disclosure officers. Perhaps, Matt, you might have some insight into that.
Yeah, so I guess I can just talk to it from the TCO and formerly DPC perspective. So our disclosure function is in our Office of General Counsel. our Director of Governance and our Executive Director of Governance are the key disclosure officers for the department, and their briefs are considered by the General Counsel, so we keep it within that area. It's certainly, the policy is clearly, articulated to the department, and everyone knows who the disclosures officers are, and yes, so that's how we do it in TCO.
Our organisation has a somewhat analogous arrangement. We've got line responsibilities for different aspects of PIDs, so between myself, the Solicitor of the Commission, and also the Chief Executive Officer, and below them, of course, obviously the managers. So that's clearly articulated, so people understand the process that operates, and I anticipate that most organisations would have analogous arrangements to deal with the matters.
Paul, you mentioned earlier that agencies have an obligation to report certain data to the Ombudsman's office, and of course the agencies are going through that process at the moment. Perhaps you could just talk to us a little bit about the changes, because there are additional reporting requirements under the new Act, and perhaps just about the fact that we are obviously collating that data and what it might show.
Yeah, so the data that we've previously reported about the operation of the PID Act 1994, we did report annually on the data that was provided, but it frequently gave what I think was an imperfect picture of the PID landscape, particularly recognising the possibility that a PID might be made internally, it might then be referred on to ICAC, and so there's all these questions about double counting, etc. I think the most important thing, and we haven't drafted our first annual report of agency returns yet, but when we do that, I think one of the things we have to be quite careful about is not sending a message, even implicitly, that the fact that an agency may have received during a year a large number of public interest disclosures is somehow a bad thing, or that there's some league table about, these agencies must be riddled with corruption because they've received so many PIDs that raise concerns about potential corruption. Because as the Chief Commissioner said, it's quite frequently the agencies that report no suspected corrupt conduct or maladministration, etc., which are the ones that should be the focus of our concern and our worry. And in fact, an increase in the number of PIDs, and I expect there will be an increase in PIDs this year compared to last year, just with the increased awareness of the new legislation. I think we should see that as a very positive thing, going to that culture where people feel comfortable. They see something that looks to them might be wrong. We don't expect them to investigate it themselves. In fact, they shouldn't go and investigate it themselves. They should raise it. Whether it turns out to be substantiated or not, it's still in the public interest that they raise that matter, and so we should be welcoming those numbers.
Definitely. Chief Commissioner, this is a little bit off the side, but I'm really interested in some of the corruption prevention work that you do, because obviously there's a clear linkage between raising awareness around corruption prevention and encouraging people to come forward when they see corruption. Could you just tell us a little bit about that?
Well, we thought that it was important following our Operation Keppel report to highlight to agencies particularly the role of the head of an agency to report under Section 11 of our Act, which is a mandatory obligation. Now, that was the first occasion where we made a finding of serious corrupt conduct on the basis of someone who had an obligation to report, but on the basis that there were reasonable grounds to suspect corrupt conduct, but failed to do so. So following that, we embarked on a revision of our guidelines to assist agencies to understand the basis upon which reporting should be made to the Commission. That was distributed to the heads of all of the agencies. We also followed it up with some very detailed education work, promoting the importance of reporting. We targeted a number of agencies which we felt were under-reporting and drew that issue to their attention and had meetings with senior people to express our concern about what we felt was occurring. In some instances, we've actually targeted sectors which we felt were at risk to go out and stress to them the importance of coming forward. We continue to work with people to make sure that they understand their obligations of reporting, but beyond the compulsory reporting under Section 11, also the voluntary reporting under Section 10 of our Act, which is, again, a very important aspect of us getting information. And we stress to them that notwithstanding the fact that the Commission only investigates itself, a relatively small proportion of the matters that it gets, that reporting is valuable to us in terms of us being able to address systemic weaknesses through our corruption prevention work. And I mentioned before areas such as lobbying, where we've been able to make some difference by exploring that issue and providing guidance to government as to how best to address that matter. But also to provide an intelligence holding which we can use for our future work. Sometimes we get anonymous referrals in. We're not able to act on it. We don't have sufficient information, but we're able to marry that up with other information that comes through, and eventually we get a pattern of what's happening in a particular matter and determine an appropriate way forward. On occasions we've had matters where we didn't feel in the end that it was a matter for us to investigate, but we've referred it back to the agency. That's an important aspect as well, because we need to ensure that agencies themselves take a responsibility for fighting corrupt conduct and being addressed the issues and then reporting back to us. In a number of instances, and it is important also when we're talking about protected disclosures, because sometimes people aren't confident that their own agency is able to fairly look at the issue which they have raised, and therefore they come to us. But if we do decide that it's not a matter for us, and we will refer the matter back, we can ask the agency themselves to develop an investigation plan. We can look at the investigation after it comes in. We can then decide whether the agency has appropriately addressed the issues, the systemic weaknesses. We may even, as we have in some instances, decide, well, notwithstanding that matter, we need to look at that issue further. So there's a number of different avenues we can take, but it is important, as I want to stress to the audience, that those complaints coming in, because without them we're not in a position to be able to understand the profile of the agency and its resilience towards corrupt conduct.
Right, thank you very much. And I think that's a really interesting point, and we look at it from the PID perspective as well, and to understand an agency's, I guess, maturity in dealing with PIDs, and the data will also help us understand that. So as we come to an end with this session, I'll just put it to each of you if you have any closing remarks or key messages that you think that the audience should take away. Might start with you, Matt.
Just one thing that I've been thinking of as we've been talking today is that, a speak-up culture is so important, because potential misconduct gets to the attention of senior managers in the organisation or to an integrity agency so that it can be stopped and investigated. So it really is an important culture to foster.
It is. And Chief Commissioner?
Leading from the top, I think, is very important. Managers and senior executives have an important role in fostering a climate of corruption resistance, and a speak-up culture is very much part of that. They set the tone, they set the parameters, and if they provide appropriate support to their staff to be able to make complaints where they think circumstances justify it, then I think we've made an important inroad into ensuring that our agencies remain accountable, transparent and serving the public interest. And this is particularly critical in fostering a climate where our public institutions are respected and not undermined.
Yeah, definitely. And Paul?
Yeah, maybe just building on that point, I mean, one thing to note is they're called public interest disclosures for a reason, which is that the disclosure is in the public interest, and as public servants, it's our responsibility to act in the public interest. But on the point of the role of leaders, chief executives, senior executives, I think my message there is really, I think sometimes as senior leaders you can forget how intimidating you are to the staff within your organisation just by virtue of your role and authority, etc. And you know, I've heard a lot of very senior executives commenting about, you know, I didn't expect that my job would be involved so much dealing with problems, dealing with troubles. I thought I'd be, you know, strategizing, delivering operations. And I think as leaders, we need to be very, very careful that those who bring us information about those troubles that we have to deal with don't get the message that they are not welcome or that the news is not welcome, even to the extent of perhaps saying to people, look, if I look disappointed, it's because I'm disappointed to hear that this might be going on in my agency, but I absolutely thank you for bringing it to my attention and we'll act on it, and you've done the right thing, and I'm really pleased about that, because people do pick up on, when we talk about culture, it is those subtle micro messages that people really do pick up on.
It is, and they all kind of build up to a perception. Okay, well, thank you very much. I've really enjoyed this session, and thank you for the opportunity to ask you those questions. It's really interesting to get your perspectives as the heads of agencies and part of the agencies that you represent and lead. For those of you who've joined us, thank you for joining us over your lunchtime. I hope that we've been able to answer your questions. The links to this session will be available this evening on our website. And if there are any questions that have not been answered, we will do that by the end of the week as well. We'd really welcome it if you could distribute the link to your colleagues or your staff and really help us spread the PID message. Thank you.